This is Risk on Air, a law cover podcast, and today's episode, Navigating Risks for Executors. Welcome to Risk on Air. I'm Julian Morrow, and today on this law cover podcast, we're joined by one of law cover's finest. Jennifer McMillan is the Manager of Practice Support Services at Law Cover and is also an accredited specialist in wills and estates, having practiced extensively in that field also. So, talking about wills and estates on a Law Cover Practice Support podcast must be your dream come true, Jen.
It pretty much is, Julian.
Welcome. It's great to have you. Now, let's go back to the basics. What are the duties of an executor?
Look, they're not terribly complicated, but there are certainly places where people can trip up. The sorts of things that lead to claims come from executors neglecting some of their basic duties, and those basic duties, firstly, to identify, preserve and get in what the assets of the estate are. Secondly, to identify any liabilities and discharge liabilities that should be paid, and there's a qualification on that. You shouldn't be paying liabilities that you shouldn't be paying. So if you've got a statute barred debt, for example, you're doing the wrong thing if you pay that.
Right.
So, they're reasonably fundamental things that in most estates are pretty easy. And then once you've done those things, what you've got to do is distribute the estate in a timely manner in accordance with the will and the law, or if you've got an intestacy, in accordance with the rules of intestacy. Underlying all of that is the duty that all people in a fiduciary position have to keep proper accounts.
And as you're saying, on the face of it, that seems relatively straightforward, but I understand that this is not an uncommon area for law cover to have to deal with because there are quite a few claims in the area. Is that right?
Yes, and we've noticed with claims in the area of wills and estates, it used to be that the bulk of them had something to do with a defect in the way that a will was drafted. But these days, more than 50% of the claims that we're getting seem to come from things that go wrong in the administration of the estate after somebody has died, which I think tells me that perhaps a lot of people dabble in this area, think it's simpler than it is.
And I imagine a lot of solicitors get people saying, oh, you're a lawyer, can you just help me with this thing? And it becomes that little file that's maybe on the edge of the practice, but it might be much higher on the list of risk.
Yeah, that's right. It's also the kind of file that is often delegated to a non-lawyer to do the grunt work on. And if you don't have beneficiaries who are in your ear all the time, it can be the file that somehow gets left at the bottom of the to-do list. And so things just are left to fester for a while until what wouldn't have been a problem becomes a problem.
Yeah, and the last thing we want is to add to the list of claims that law cover's got to deal with. Okay, so we've talked about those basic duties of executors. If an executor doesn't fulfil their duties, what are the rights and remedies that beneficiaries have?
Well, beneficiaries are really not on an equal playing field with the executor. They have quite limited rights. After a year has passed, they can require an executor to pass accounts. And that can often be a good way of getting things moving and potentially leading to the executor being removed if they don't pass accounts. They can bring an administration suit. What we're finding more often, though, it always used to be extremely difficult to get an executor to be removed. But in recent years, the courts have been more willing to jump in and appoint an independent administrator where there appears to be a dispute either between executors or between executors and beneficiaries. So that is one thing that might lead to a better outcome for beneficiaries.
Right, so the removal of the executor, you say there are more cases of those, and there was certainly one recently in the Victorian Supreme Court, the case of Nemla Aquilina versus Makada. This was handed down on the 25th of September 2025, but it is a hell of a story, Jen. Pretty stark example of an executor engaging in misconduct. What happened there?
Yeah, so as you say, this really is right at the extreme end of an executor doing the wrong things. And you had an executor of an estate where the deceased had been predeceased by his own wife. His estate was left equally to his 3 children, and if any of those children had died, to the children of those children. So in the event that happened, there were 3 children. The middle child had died, leaving a granddaughter, and one of the things that the executor did was to be completely unreasonable about recognising that that granddaughter was entitled as a beneficiary of the estate.
Well, yes, because you just said granddaughter. That doesn't sound like a controversial statement, but it proved a little more controversial than usual in this instance.
Well, it really ought not to have, because there was evidence in the form of her birth certificate, which showed who her father was,
A fairly conventional place to look for these sorts of things.
and her father's death certificate, which noted her as his child.
Okay, 2 from 2 so far.
Yeah, but nevertheless, the executor demanded DNA evidence, which was always going to be very impractical to get, given that her father had died many years earlier. And it wasn't until right before this hearing that the executor conceded that, yes, this person was a beneficiary of the estate as the daughter of the deceased, child of the deceased.
That's amazing, yeah.
Yeah, it was ridiculous. But that was only one aspect.
No, exactly. This sort of case has got a bit of everything, hasn't it? And I suppose an interesting point here as well is that you might think when there's that sort of very, very confrontational conduct in the administration of a state that it was perhaps a aggrieved family member who was the executor, but that wasn't the case here.
No, all of the family members were in agreement
Yeah.
that there was no question about the paternity of this person. So it was really very hard to understand.
And who was the executor?
Well, the executor was the solicitor, and this is really, it doesn't do the profession any favours to have a solicitor executor behaving in this kind of way. So she was the solicitor. She would have been a co-executor with the deceased's wife, but of course the wife predeceased.
So the solicitor effectively has the sole carriage of the administration of the estate.
That's
then.
right.
And proving the identity or the paternity of the granddaughter was only one aspect. Tell us about some of the other things that went on.
In some ways, it's the other aspect that's even more alarming. So I mentioned that the deceased's wife had predeceased him, and the executor entered into an agreement with the executor of the wife's estate that the wife's estate would receive 40% of this estate, contrary to the provisions of the will, and pursuant to what looked like a pretty dodgy and almost certainly unenforceable financial agreement that had been signed at a time when the deceased was under orders from VCAT because he didn't have the capacity to manage his own affairs, and there was no solicitor's certificate, which is a formal requirement of a financial agreement under the Family Law Act. So what it looked like was happening was the executor had made up their mind that the wife's estate should be entitled to 40%, and even in the face of disagreement from the beneficiaries, she didn't get any independent advice about that. She didn't seek judicial advice about that, and she was just merrily going to hand over 40% of the estate to the executor of the deceased's wife's estate.
Yeah, it's not a good sign when a judge has to focus on the fact that the basic responsibility of the executor is to distribute the estate in accordance with the testamentary instructions. So this is a pretty outlandish case on the scale.
Yeah, it is. And I mean, you will have situations where somebody asserts that they're entitled to something from the estate. It might be a debt that's owed to them. I mean, really what the executor needs to do is make an initial assessment of whether, yes, this is a genuine amount that needs to be paid to this person because there's some contractual obligation there. And if there's any doubt, you certainly don't do anything either without the full agreement of the beneficiaries, assuming that they're all adults and able to provide their consent.
As opposed to the full disagreement.
Or you go to court and you ask the court to provide judicial advice. And the point of obtaining judicial advice is so that you can be comfortable that you can go ahead and proceed in accordance with what the court says you should do, and there'll be no comeback against you by the beneficiaries. Otherwise, you're exposed to personal liability for it.
Always better to avoid court if you can, but much better to be going early and getting clarification and advisory opinion. Does that happen much in wills and estates?
It does happen quite often that there'll be an application for judicial advice. And really, in my view, there's no reason for an executor or an administrator to be taking personal risks in the way that they administer an estate. So if you've got a genuine question about what the correct way forward is, you protect yourself by applying to the court for judicial advice. It does involve generally getting an opinion from senior counsel and then making an approach to the court. So yes, there's some cost and time involved in doing that. But why an executor would risk personal liability, I just can't imagine. I think it's so much better to obtain judicial advice.
And unsurprisingly, in this case, even though as a general rule, an executor's costs might be able to come out of the estate, given the impropriety involved here, it became a personal liability of the solicitor.
It did. It's actually quite unusual for an executor not to be able to have their costs fully indemnified from an estate if they're doing all the things that they should do. It was so clear that this executor was not doing all the things that they should do, and Justice Moore talked about a lack of understanding, misconception and disregard about key aspects of executorial responsibilities. The order that he made was that she in fact pay the costs of the beneficiaries personally.
On an indemnity basis.
On an indemnity basis.
Right. So, yeah, don't want to use that as a model for practice, but a pretty stark cautionary tale. Let's go back to some of those duties. You mentioned earlier the duty to maximise the estate. What does that require of an executor in practice?
So lots of assets are really easy to identify. There's bank accounts. You can write to the banks and find out what the balance is. You know that there's real estate. If you don't know where the real estate is, there are searches you can do to find it. The one asset that is not infrequently overlooked is where the deceased maybe had a cause of action against somebody. And increasingly in these days when we see really pretty awful levels of elder abuse where somebody becomes frail and dependent on an adult child who either as their attorney or just because they happen to have the PIN number to their bank account helps themselves to the person's assets while they're still alive.
So by the time the administration of the estate comes around, the pot is a lot smaller than it should be.
Exactly. And there is a cause of action against somebody who has basically stolen from the deceased. And if you don't pay attention to the possibility that there might be a cause of action against somebody and you're the executor, and that cause of action then becomes statute barred because 6 years elapses without you having taken any action to recover funds that should have been recovered, then there's a Latin word devastavit, which refers to a wasting of the estate, and the beneficiaries have then got a remedy against the executor for allowing that to happen. So you really, particularly if there are rumblings in the family that when Mum sold her house, she got $3 million for it. I can't understand why there's now only $100,000 in her bank account. And my sister was her power of attorney for the last 3 years, and she seems to have bought a caravan and a boat in that time. You don't ignore that stuff because if you do, then it can come back and bite you.
And what was that Latin term again? Devastavit. And so that's the diminishment of the estate, is that right?
That's right.
Yeah.
So it basically comes from the word wasting.
Okay. And that's an action which has been pursued successfully in Australian courts?
It has. In fact, there's a landmark case of Bird and Bird from the Court of Appeal in 2013. This was a case where there were 3 executors and one of them was a solicitor. And while the person had been alive, he'd appointed his wife as his attorney, and his attorney had sold some properties and she deposited the proceeds into her bank account.
Her bank account?
Her bank account, which would have been fine if she was entitled to the whole of his estate, but she wasn't entitled to the whole of his estate. And there was a daughter who was not one of the executors, and she raised this with the executors and said, this needs to be taken into account because the estate is not as big as it should be. I'm one of the residuary beneficiaries. I'm entitled to more than what you say I'm entitled to. The daughter was ignored and the action against the attorney became statute barred because the executors did nothing within 6 years. And then almost 6 years to the date after it became statute barred, the daughter commenced proceedings against the executors. And so you had a misdeed by the attorney that had happened way back in 1993, and it wasn't determined until 20 years later in 2013 that the executors were actually personally liable to make good the estate for the loss that had occurred because they hadn't called in that asset.
Wow, yeah. So 20 years later, and the interest calculations on that would have been pretty fierce.
Not nice, yeah.
Right, okay. So that's definitely something to look out for, the fact that maximising the estate includes the value of actionable claims.
That's right. And that's the easiest thing to overlook because, you don't necessarily have an obvious way to search for that.
It's easy to say the words actionable claims, but is there a practical sense of how deep or how many types of claims you might need to consider? That could be quite a tricky thing to satisfy yourself about, couldn't it?
I think it can be especially tricky if you're an independent executor like a solicitor who doesn't really have a lot of knowledge and understanding of what's gone on in a family before the person died. So it's really important to talk to your main residuary beneficiaries and understand from them what they're expecting to be in the estate and just have those conversations. It doesn't mean that you need to waste a lot of time and money going down rabbit holes, but if there are red flags going off that require investigation, and I kind of think anytime you're on notice that there's been an active power of attorney, you at least ask to have a look at that power of attorney to see what it allowed to happen, and then ask that attorney for accounts. Sometimes, in fact, more often than not, they will not have kept good records, but you're discharging your duty by asking those questions, and it might give you an inkling then of whether further investigation is needed.
And no doubt, even if nothing does arise, it couldn't hurt to have a very clear record in either correspondence or a file note that you have asked these questions, alerted the beneficiaries to the possibility that not pursuing claims could be an issue, so you're trying to find out what there might be.
Absolutely. And it's particularly going to be important when you know that you've got somebody who was frail at the end of their life and needed somebody else to help them with their affairs. And 9 times out of 10, there's going to be nothing to see here. But we do know that it's a growing scourge.
Yes.
That there is elder abuse that goes on, and to put your head in the sand is definitely not the answer.
So that's maximising the estate. I suppose the other side of that equation is, what about the liabilities of the estate? You alluded earlier to the possible error of paying something that doesn't have to be due, but more broadly, when we're looking at the liabilities on an estate, what does an executor have to be aware of in that department?
So the first thing to be aware of is that it's always a good idea to publish a notice of intended distribution of an estate, because that will act to protect you personally in the future against claims from creditors who didn't respond to that notice and tell you that they were owed money by the estate. That helps with most creditors. There's one creditor it doesn't help with, and that's the tax office. So it's really incumbent on an executor to ensure that any tax liabilities are identified and paid. And that can be easier said than done.
Right, so possible tax liabilities. What sort of categories of liability should practitioners particularly be looking out for?
So when we look at the kinds of claims that have come in recently, the one that seems to be overlooked most often is where the executor or administrator receives a super death benefit payment from a superannuation trustee. And when they receive that payment, they receive a gross payment from the super trustee and a statement that sets out how much of it is taxed and untaxed and taxable. And it's up to the executor to look at the will or the rules on intestacy and work out how much of that death benefit is going to end up passing through to people who are tax dependents for the purposes of the 97 Tax Act, or people who are not tax dependents. And significantly, an adult independent child is not a tax dependent. So if you've got a super death benefit that's passing to an adult independent child, then the alarm bells should be going off for you. And in that year in which the executor receives that super death benefit, they should be declaring in the trust tax return that they've received a death benefit that is ultimately going to go to somebody who's not a tax dependent, and they should be paying tax on it. And if they overlook that step and then go ahead and distribute all of the estate, and then the tax department comes back to them because they've been notified by the super fund of this payment and want to know why they didn't receive any tax, it's really, really hard to get money back from beneficiaries once you've already paid out an estate. So
Yeah, and absolutely no surprise that sort of unexpected tax liability is the sort of thing that's going to give rise to complaints and disputes.
Completely. And I don't think that it's reasonable to expect that solicitors will necessarily be entirely across all of the issues around tax and deceased estates, but they should at least understand what the red flags are and know to get proper advice from an accountant who's well versed in the area so that they can just have the comfort that they or their clients aren't exposing themselves to personal liability.
Okay, so superannuation death benefits is one area to look out for. Any others?
So capital gains tax is the other big one, and most people would be aware that if you've disposed of a capital gain asset during the administration of an estate, you're going to have to set aside and pay some capital gains tax. The thing that can trip people up is this tricky thing called a K3 event that can happen if you've got a will that is leaving a capital gains asset to certain tax-exempt or tax-preferred beneficiaries. And those beneficiaries would include a tax-exempt charity that's not a deductible gift recipient, or a regulated superannuation fund, or an overseas beneficiary who doesn't pay tax in Australia. So just be mindful if you've got beneficiaries that check any of those boxes, you need to be on the alert. And again, get some specialist tax advice.
Yep, so publish a notice of intended distribution, consider the tax implications and get specialist advice as a precautionary option. Now, Jen, delay in the administration of estates regularly makes up, I think it's about 13% of complaints to the Legal Services Commissioner in New South Wales. Is that also an area of claims and disputes that Law Cover's aware of?
We certainly find that we get fewer claims than the Legal Services Commissioner
That's
gets
reassuring.
complaints. And there's a natural tension there. Beneficiaries always want to have their money yesterday, and they often don't appreciate the work that needs to happen before an estate can be distributed. And they also may think that it's ridiculous that the executor wants to wait out a year in case there are any family provision claims. So you can see that there's a natural tension there. Having said that, though, there are sometimes situations where an executor really neglects in a terrible way the administration of an estate, where, for example, a solicitor might have substantial funds sitting in their trust account for a long, long time, not earning any interest, and there's no real reason why the estate can't be distributed or why that money can't be invested in an interest-bearing account at least, so that it's not wasting away. So the general rule is that an executor's got a year to do what they need to do. If things click over beyond a year, then you need to be careful, because if somebody's entitled to a money legacy under the will, then they're also entitled to interest on that legacy if it's paid more than 12 months after the person died. And you also need to be aware, for example, if there's a house to be sold that was the person's main residence, after a certain time period, that will become liable to capital gains tax, where if it's disposed of promptly, it can still qualify for the main residence exemption.
Yeah, delay to be avoided. I think the disciplinary case that I've come across which has the longest delay was a Tasmanian disciplinary matter in which there'd been no significant progress in a matter for 24 years. You'd want to come in then under that.
You certainly would. And that sounds like an instance of a file that's fallen to the bottom of the filing cabinet, doesn't it? It sounds like a situation where the beneficiaries either don't know that they're beneficiaries or they're not calling the executor regularly to get an update. And that can be a real risk in law firms, that these are the files that, if there's no squeaky wheel, they don't get the attention that they need.
And you'd hope that that would be remedied within 2 decades at least. But of course, better, I suppose, to take a little more time than to make an error in distribution, especially if it's due to haste. What sort of claims and risks are at the front of your mind, Jen, in terms of incorrect distributions?
So maths is one of those things. Some people love it and some people hate it. And I think it's good to know yourself. And if you're a little challenged by maths, I think it's really good to get a second set of eyes on your figures, get somebody else to look through your proposed distribution, reread the will, make sure that it accords with what the will says, and just do a little sanity check on what's happening, because we've certainly seen instances where there should have been a distribution going to 5 children and it's only gone to 4, or things like that that really ought to be picked up by having a second set of eyes or just by taking your time to
Yeah.
go back and look at the will and double check.
And whether it's in the States or not, we've all heard the horror stories of formulas in spreadsheets that go awry and they can persist for a long time. So, yeah, always good to have a second set of eyes.
That's right. And just do a little sanity check. Like when you reread the will and you look at what's happening with the distributions, does it make sense? One thing that causes lots of problems is adjustment clauses in a will. So this is where mum during her lifetime has given some money to one of two children and she wants to treat them fairly. So in her will, she says, please adjust that. And, depending on the way it's worded in the will, it might be a bit unclear about how exactly that's to be adjusted. And I think it's really important to go back to the will, make sure that you're doing it exactly by the letter. I've seen some really, really difficult and complex adjustment clauses where people try to, for example, adjust for the likely capital gains tax liability where an asset that's subject to capital gains tax is passing under the will. And I think that's nigh on impossible to do with any accuracy. So it can be quite difficult. And sometimes these are the kinds of situations where you might even ask the court to make a determination on a construction of the will if there's a difficult adjustment clause in there. Better to do that than to just make a call on how you think it should work and pay the money out, because once it's gone, it's hard to get back. But with distributions, there are a whole bunch of other things that can cause problems. We get the odd claim where a distribution has been made to a beneficiary who was bankrupt, and a lot of solicitors will ask the beneficiaries to provide a statutory declaration, and one of the things in the statutory declaration will be that they're not an undischarged bankrupt. The problem is, if someone makes a false declaration, it's not going to be much help to you if the trustee in bankruptcy comes and demands that that money be paid to them personally by the executor. So I think it's a good idea to at least tell your executor clients that it's possible relatively inexpensively and quickly to do bankruptcy searches of beneficiaries. Even within families, people don't always tell each other if they're bankrupt. So it's a good thing to be aware of. And the other thing that has caused a number of claims where money should have gone to a beneficiary and didn't has been where there's been an email fraud. So the solicitor has asked the beneficiary to email their bank account details so they can make a distribution, and they haven't properly verified, either by picking up the phone or by getting the executor to check, that that person is in fact the right person and that those are the correct bank account details.
And of course, that's the nightmare scenario, because presumably a large amount of the estate and the financial value of the estate sitting in a trust account, then there's a fraud, and yeah, that seems
That's
like
right.
scenario you want to do everything that you can to avoid, bearing in mind that the way those scams work is always by just the slightest human error. So it's one of those areas you've got to constantly check yourself, recheck, and make sure you're using the proper method.
That's right. And I've got some sympathy for solicitors with estates and email fraud, because it's not like money that you're sending to a client where you've got an ongoing relationship. Often with a beneficiary, this is the only contact that you have with them, is to ask them for their bank account details. So verifying the bank account details, it's a really important step, but it can be a little trickier to do than with a client who presumably at some stage will have actually come into your office, and you will have been able to check their identification and to ask them then and there for their bank account details.
Yeah, so lots of different things to look out for in terms of incorrect distributions. What about changing regulatory or statutory environment? Is that something that arises much in wills and estates?
Not so much. We had a lot of reform about 2009, 2010, and one of the things that was reformed quite substantially was the intestacy scheme. So it meant that the way that an estate would have been divided before those reforms was quite different to post those reforms. But they're now far enough in the past that most solicitors can't even remember what the old scheme was.
Good to know, good to know.
But the thing that people need to be aware of, especially if they're asked to assist with the administration of an estate of somebody who died, say, 20 years ago, which can happen, you need to realise that it's not the current intestacy scheme that will apply, and you will need to hit the books and find out what the old intestacy scheme was to make sure that it's the right people who are receiving the estate.
Well, look, so many areas to be aware of in terms of wills and estates. And again, just to reiterate the point that this is an area that Law Cover is seeing more notifications and claims on.
That's right. And I think as we have an ageing population, it's probably going to be only more and more of the proportion of claims that we see as estates fall in. And people's affairs are complex. You know, it's rare to have an estate that doesn't have some element of superannuation involved. Everything is just a bit trickier than it might have once been. And people assume this is an easy area, and it's really not.
Yeah, so lots of precautions to take, and in many cases worth getting specialist advice before making decisions that could be regretted. Jen, thank you so much for joining us on Risk on Air.
Good one.
That's Jennifer McMillan, who's the Manager of Practice Support Services at Law Cover. Thanks for listening to Risk on Air by Law Cover, and to stay up to date, join us for the next episode on current risks in legal practice.